Hello and welcome to another in-depth episode of Israel Update. And today I'm speaking with Professor Moshe Cohen-Eliyah, who is the former president of the College of Law and Business. Moshe, hello.
Hi, great to have you here.
Thank you for making the time. We are convened here to understand a landmark in Israeli jurisprudence, the 700-page decision of the Supreme Court, which struck down what we have for a constitutional amendment. Is this exaggerated to say that this is a change of Israel's regime?
I think in some ways we are nearing a conclusion. Maybe some political scientists would have to dwell more into it, some kind of a change of regime. Because once the Supreme Court strike down a constitutional amendment, and it does that on the basis of the doctrine, which is very much controversial everywhere across the globe, the doctrine of unconstitutional constitutional amendment. It's a very strange name, which basically gives the court the power to strike down constitutional amendment. And when we look at the case, there are two layers. Okay? The first layer is the following question: does the Israeli Supreme Court have the power to strike down a constitutional amendment? As we look at the text of the Basic Law, there is no explicit authorization in the Basic Law granting the court such power. But what we see elsewhere in the world, where we are actually experiencing some kind of controlled battle over the Supreme Court, we see many Supreme Court basically outside the Western world. For example, in India, Bangladesh, we saw it also in Slovakia and other countries in Latin America, using this very highly controversial and which lacks democratic accountability doctrine called unconstitutional constitutional amendment to strike down what they perceive to see as an attack on their own legitimacy, their own authority, and their own power. And
But Moshe, Israel does not have a constitution. So let's lay this out. Let's unpack this for our
Actually, it's
American
a very
listeners.
important question because, you know, Israel is basically, was at least in the past, parliamentary democracy, like the British kind of model of Westminster kind of countries in Australia, in New Zealand, once in Canada, the UK, of course, which don't have a constitution and believes in parliamentary sovereignty. But what Israel has experienced since the 80s, once the very charismatic justice, which was later the Chief Justice of the Israeli Supreme Court, Aaron Barak, entered the Israeli Supreme Court, we saw massive transfer of power in three waves. The first wave was in the 80s, where the courts basically expanded the doctrine of reasonableness, shut down all kinds of procedural barriers such as standing and others, and basically expanded its power. In the 90s, once the Israeli Knesset adopted the Basic Law, human dignity and freedom of occupation, Aaron Barak immediately labeled it as a constitutional revolution. And very steadily and very focused, he expanded the notion and the scope of the Basic Law and actually changed Israel regime from being a parliamentary democracy into a constitutional democracy. There was some basis for that. I don't think this is totally flown. It was very much expanded beyond what the Knesset meant. But, you know, when you look abroad, you look at many countries' democracy, they have a constitution. What we are experiencing now is, I think it's the third wave, which actually says that Israel is no longer a constitutional democracy. It can be labeled as a juristocracy. Let me explain what the meaning of juristocracy is. Professor Ron Hirschel, who is a very famous professor from University of Toronto, Texas, is a world-known expert in comparative constitutional law. He dwelled very carefully into what he says is a new constitutionalism that started after the collapse of the communist bloc at the late of the 80s. And we saw rapid processes of democratization across the globe. And what Ron Hirschel points at is a very dramatic transfer of power, usually from hegemonic elites that are in demographic decline, and they transfer more and more power to an institution that they still control, okay? So, and I think what Hirschel also says in the book, that what he had in mind was basically Aaron Barak, is the paradigmatic case of a massive transfer of power with a very dubious legitimation from the Knesset or from the Israeli public. And I think, and he said at some point, this country might turn into a juristocracy. And I think after reading the 748 or something pages, which in English is more than 1,000 pages, and we'll speak about the length of this decision and what does it actually mean, I'm very much curious to know if a political scientist would look into the structure of Israel's so-called democracy, and he would ask himself, who is the sovereign in this country? After reading this I see it as a sign of conceit from the court. It's not a very humble kind of judicial decision making. And I see the way that they see the people in terms of populism. They are the irrational, they are the populists, they are the dangerous, we are the elite, we are protecting democracy. I felt in much unease in my chair at 3 a.m. in the morning after reaching page 300 out of 748 pages. When the court says that the basis for its interpretation of its power to strike down a constitutional amendment is the declaration of independence of the state of Israel, this is a very bizarre kind of legal reason. Why? Because the declaration of the state of independence of Israel can be interpreted in many ways. Actually, the word democracy does not appear in the declaration of independence. It refers to a certain political and anti-discrimination rights, but it doesn't speak in terms of democracy. It speaks much more in terms of Jewish state, even referring to the Bible. Okay? So it's more a question of who interprets rather than what we actually interpreting.
Because the document itself, it was never intended to be a constitution.
Yeah.
Consciously, the people who signed it never thought it was a constitution.
Yeah,
the courts didn't think it was the constitution. The Knesset was supposed to write a constitution and did not think of it as a constitution.
It's saying very clearly in the Declaration
but what is happening,
of
Moshe? And I want to unpack and backtrack through our conversation. What we reached when you say a juristocracy, what this actually means is that the parliament is completely subordinate to the court. There is no act of parliament with no majority whatsoever that can influence the decisions of the court, and the court can strike down any action, any legislative action on the Knesset. So am I too blunt to say Israel is not a democracy at all?
It's a question of degree, okay? I think we made a huge leap toward juristocracy, and I think there's a difference between the analytic question, who is the sovereign, okay? When I'm reading this case, I would say, well, this is not actually democracy, okay? And political way of understanding the powers and the power struggles around, it's more complicated than that. But bluntly saying, yes, if it is the court, that only the court that has the authority to interpret the Declaration of Independence or our underlying values, which are extremely vague, okay? And we don't like that interpretation. There's no way out. the last word is only assigned to the judges. Well, I can say, okay, but I want to control the judges. I live in democracy. We look almost everywhere across the globe. In many countries, it is the politician that select the judges for the Constitutional Court, for the Supreme Court. There are all kinds of balances. But as I am reading that, if the Israeli government would want to reform the selection committee for judges in Israel, it won't be able to do that, because the courts was previously saying that the standard for striking down a constitutional amendment is extremely high. These are very, very, very rare cases that shock our conscience. That's the rhetoric that Chayut itself, the president of the Israeli Supreme Court, used a few years ago in another decision. But when you look at this narrowing of the reasonable test, which is hardly being used across the globe, and for the Israeli Supreme Court, at least 8 out of 15, this is almost a disaster, the end of democracy, the end of the rule of law. I don't really believe that the judges themselves believe in what they're saying. Okay.
So let's explain what they are saying, because let's now do it chronologically. In Israel, you said the first revolution was the reasonableness clause. You're referring probably to the Pei Zahav 1985 ruling. So let's start by explaining this. What is the reasonable clause? Why did 85 become a landmark?
Okay, and that's a very interesting story. Okay, because when you look at common law countries like Great Britain, Australia, New Zealand, and Israel, there is a test called the Westbury test, which actually saying that it is okay for the courts to intervene in a decision, administrative decision, that is so flown, that is absolutely ridiculous. In extreme cases, then the court can also intervene in decisions that are totally or extremely unreasonable. Okay.
An example, Moshe.
When you look in Israel, there are two kinds of cases in which Israeli Supreme Court intervene in cases of reasonableness: nomination. By the way, in no place across the globe, at least in countries that I came across, courts never intervene in nomination, especially not on the basis appointment, nomination to all kinds of position. This is totally out of judicial review.
Oh, but I wanted an example of what should be counted as extremely unreasonable, like in the original before the Pei Zahav. So
actually, I can hardly come across cases in which courts actually intervene. It's usually totally irrational. I don't have specific cases in mind.
So a hypothetical, what would be? Let me give you an example. Tell me if it's if Tel Aviv municipality decides that you can't park in Tel Aviv anywhere. That would be extremely unreasonable, right? That's crazy.
I think it's all depends on the circumstances and the menaces and the dangers. So I find it very hard to speak about it very hypothetically. But what happened in Israel is that this very, very narrow test has expanded dramatically. And why did it expand dramatically? To actually substitute the discretion of the decision maker. Why? Because the vision of Aaron Barak is a world in which everything is subject to the law. And whenever there are places that law does not apply, this is a black hole. And black holes are very dangerous because they lead to corruption. And because the court itself is very smart, and judges are learned and they're objective and they can balance correctly and they can apply their judicial decision making
according to Aaron Barak.
Yeah,
that's not our court.
Then we should keep this power of supervision always, all the time, even on military operational cases. There was a case during the second Intifada in Jenin, in Bethlehem, where from the court itself, during an operation, in the nativity church, I think in Bethlehem, there were orders coming from the Israeli Supreme Court during the time of operation. How to conduct that? I think you can never come across such a level of intervention in any other country across the world. So Israel is a very, very extreme case of hyperactivism. And by the way, it is well known across the globe. Israel and the legacy of Aaron Barak is very much related to hyperactivism.
So would it be correct to say that the test of reasonableness, when it's not extreme unreasonable, it's like not someone calling a street on the name of Adolf Hitler in Jerusalem, right? It's what happened with the expansion of reasonableness is that now the judge can apply his own opinion, and on the basis of his own subjective idea of what should have been done, can undo what the other two branches of government do. Just replace you call it the discretion of everybody else with what the judge think is a good idea. Is that
it's even worse than that, okay?
How?
Because basically it's true, when I'm substituting the way that the decision maker balanced all values and interests, then I'm actually engaging in political activity. This is policy making in a way. So when you're reading the case, the President Hayut saying, well, when she tried to present this amendment as disastrous, so what's the way to present it as so apocalyptic is to relate to the argument that there were only 40 cases in which the Israeli Supreme Court intervened in the reasonable case during the last year, if I'm correct. Maybe I'm not very accurate about it. But what Hayut is actually saying, no, it's more than that, because it affects the attorney generals. And the attorney general also direct the government. So there are many, many other cases that because of the way that the court applies the doctrine of reasonableness, they also have effect on real life. I call that in another respect the culture of justification, which basically actually changed the government position in fear of court's intervention. So the effect of this doctrine is very dramatic. And there's one more interesting point, a sociological point. There was a very seminal article by a very left-wing sociological and law professor, Ronen Shamir from Tel Aviv University, about the role that reasonable test actually plays in Israel and in many other liberal democracies. And basically, he was arguing, and I think quite convincingly, this is a way to control people, okay? This is the way to delegate more power to what he called the Mandarin bourgeois, okay? The professional kind of bourgeois that have their power and prestige from their expertise, okay? So we turn the notion of reasonableness into something that only experts, which are legal experts, should have the power to decide. But as you correctly said, well, when you're actually engaging in policy making, this is politics, okay? So it's not a question about expertise, it's a question about political preferences.
So now just to fill in the gaps for those who have not been following Israeli news, there was a judicial reform suggested by the Netanyahu government through the agency of Yariv Levin, the Minister of Justice, and Yariv Levin wanted to move against the idea of reasonableness in order to take away from the court the arbitrary ability to intervene and strike down things not on the basis of legality, but on the basis of the opinion or the taste or the values of the specific judge. So in order to institute that, after a long struggle, the parliament, with a majority of 64 out of 120, amended the basic law jurisprudence, basic law hashfita, basic law
judiciary.
Basic law judiciary. Thank you. It's a basic law. And in this sense, it's a constitutional law, because part of the function of a constitution is to create the institutions and the relations between them. So there is a basic law judiciary, and what Yariv Levin wanted to write into it and did is an amendment saying that the reasonableness would be limited in cases of political decisions. That's all. And the court declared that this is the end of the universe and struck down a constitutional amendment, thereby changing the relations between the branches of government. So they keep talking, Moshe, about a conflict of interest. Isn't this the arch conflict of interest, where the court decides that the parliament cannot decide what the authority of the court is? The court will decide what is its own authority, and so become a deus ex machina.
Definitely so. I think we are not in the spheres of law. This is definitely the sphere of politics and political struggle. And after reading at least substantial part of this judicial decision, there's no legal reasoning there. It's in disguise of legal reasoning. Basically, it's a power struggle. And I think more and more people understand that. You know, it's very interesting to ask, why did the court intervene in such a minor kind of amendment to the power of the court? And I think that the real reason is the fear, okay, that we are now in a democratic backsliding. And Yariv Levin actually exposed the grand plan, and Israel is going to be an illiberal democracy like in Hungary and like in Poland. Okay, I want to say 2 points about it. First about Poland. I'm a liberal, okay? I never voted for the right wing, okay? But I accept the notion that democracy, you have liberals, you have conservatives, you have all kinds of views, okay? And that's not the big deal. And the question of what is democracy eventually, besides some very basic protection of human rights, is the ability to change a governance, okay? And I think after smearing the experience in Poland, okay, you see a very clean kind of change of governmental power, and now the opposition has turned out to be the coalition, and now you have troops coming to the media that was controlled by the right wing. You see a power struggle. As long as it is based on a democratic consent, as long as there's no terrible things going on and silencing and people putting people in jail if they're opposing the government, for me, that's democracy. Okay, so we were very much scared by the Israeli media about what is going to happen, and everyone who belonged to the right wing automatically was labeled as illegitimate. Not that he's wrong, is illegitimate. That's the problem in political polarization that we're experiencing. And you see, you know, once you have this fear in mind, and you look, for example, in the way that Yitzhak Amit, who is supposed to be the next president, maybe, of the Israeli Supreme Court, you read his judgment, that's what he had in mind. And he knows that it's very hard to argue that the reasonable test actually reach the level of such a shock or danger to democracy. And you see how he's struggling to lower the threshold down, because other than that, he won't be able to strike down the law.
The threshold of what?
I think this is something that the courts and the judges had in mind, and they wanted to lock the now conservative, very minor, okay, conservative majority in the Israeli Supreme Court. It's important to mention that because, you know, in the Israeli Supreme Court, there are 15 justices. 8 of them were supported the striking down of the basic law. 2 of these 8 are no longer on the Israeli Supreme Court. So what you see is a hegemony that loses power, and it tries to lock the future generation of judges by their own vision. By the way, you can see the same thing. After the Labour Party lost in the election of 1977, okay, they passed a resolution in the Israeli government a few days before the right-wing government was established to delegate more power to the committee that sponsors Israeli higher education. I don't remember what's the name in English of this committee, where the left wing has control. So when an hegemony loses power in politics, it shifts more power to institutions that are controlled by them. Either it's the academy or it is the Israeli Supreme Court.
Why is I asked you before about lowering the threshold. What do you mean that Yitzhak Amit was lowering the threshold? The threshold of what?
The threshold, what was actually established in the basic law, Israel as a nation state, the case that reached the court a few years ago, and the court did not strike it down. Okay? The threshold was very high. It said that the Israeli Supreme Court can only strike down a constitutional amendment in extreme cases that shock the conscience of every Israeli Zionist to believe in a democratic and Jewish state in extreme cases. It's a very high threshold. And by the way, the threshold was even higher in the decision of Daphne Barati as another justice.
So now trying to limit the extreme craziness of the court is supposed to be shocking to any reasonable person.
So what Amit was trying to do, he said, well, the reasonable amendment, yeah, you can argue it. By the way, I thought that the amendment was not okay. I prefer the different version of that. But still, it doesn't reach the threshold, shocking the conscience, extreme cases, the core values. It's only a doctrine. There are so many other doctrines. Maybe it's more convenient for you judges to use a very loose doctrine that gives you too much discretion. But it's tough luck. It's a tough work. You have to do your work like many other judges across the globe are doing. There's no reason for that to say, well, it's so shocking of the conscience, such an extreme violation of the core values of the state of Israel. You know, I studied law at 1989 at the Hebrew University when the doctrine of reasonableness was never applied before. It was like something that you said, well, this is very, very extreme. And I didn't believe to what extent it was expanded as part of this notion that the court should supervise everything because we cannot trust the people. Yes. You should trust the people. In a democracy, we should trust the people. I'm not saying that the majority can do anything. Okay? There's some kind of balance which is legitimate. But I think when you look at this decision, you're saying, well, someone has lost balance here. This is extreme, radical, political reasoning. It's not a law. It's political struggle.
So this decision is 740 something pages, you said, and
something like that, yeah, if I remember correctly.
Would be over
more than
10,000
in English.
Yeah, more than 1,000 in English.
Google Translate would have to work a lot.
so why it's comprised of 15 different opinions, right? All the judges express their opinions. Why do we need such an encyclopedia for a little amendment?
Yeah, you know, in India, there are several cases in which the Indian Supreme Court intervene and strike down a constitutional amendment, and it's about the same length. So why are these cases attracting so much papers? Okay,
very
so many writing, destroying the woods. Okay, if we're printing that. When your argument is weak, and it's weak, okay, then you have to cover it with a lot of citation, a lot of writing, repeat everything twice. It's such an exhausting task to read this case. And, you know, I read very quickly. I know what's the bullshit and what's to get to the point, and you don't get to the point. So much around. And the point is, we have the power, we are holding we have the last word, and we are not going to give up this power. That's the bottom.
Wow, I should write this line down. So what's in the future, Moshe? Because people who are critical of this decision say, okay, we lost this battle. They have the final word on everything, and we will just have to submit to them. While others say their hubris is just killed them because they've stepped so far beyond legitimacy that, was it Aaron Barak who said that the court doesn't have a sword or a purse? It only has the
support of the people.
The confidence of the people. So is this the final triumph of the court, or is that a Pyrrhic victory?
It's a very good question. If you look at the level of support of the Israeli Supreme Court or confidence from the 80s today, in the 80s, the Israeli Supreme Court received 85%, like the Israeli IDF. It was one of the most prestigious and most respected and non-partisan institutions. Now, the level is around 40%. With a very partisan conception. 86% of the left-wing supporter support the Israeli Supreme Court, and only 25 or 26% of the right wing. That's a very low number. By the way, it's a mirror kind of reflection of what happens in the U.S. But in the U.S., it's the Democrats that don't support the Supreme Court. So, what are the solutions? First, I see some signs of optimism after reading this very long decision. The fact that Chayut, who is the president of the Israeli Supreme Court, and one
the former president,
the former, yeah, and but when she wrote it, she was still the president. But one of the missions of president of Supreme Court is to create legitimacy and to create consensus among the court. By the way, in the very famous case of Brown versus Board of Education from the 50s in the US relating to racial segregation in the southern states in education, L. Warren, who was appointed by Eisenhower, but he was very liberal, he specifically convinced every judge on the Supreme Court to set a unanimous decision, because it said we are going to first fierce opposition, we need to speak in one voice. Chayut failed. 8 versus 7, and 2 of the 8 are now no longer on the court. That's a huge failure for leadership of the Israeli president of the Supreme Court, okay? So why do I see optimism? The fact that there are the 7, okay? Let's first say that they are not really conservatives in the American sense, okay? They are very mild conservative, or maybe less activist than the group of Chayut. But I think they are willing maybe to change the doctrine from within. I think that's the best solution. Take, for example, the next president, Solberg, who is supposed to be who is conservative, and is supposed to be a president of the Israeli Supreme Court in the future. He originally said, we made the mistake, we judges. We shouldn't have adopted the Pei Zahab. We shouldn't have expanded the notion of reasonableness. What actually now Solberg should lead the court itself to change the doctrine from within, because they are conservative. They believe in his mission. That would be the best solution. The second solution,
but I'm an American historian, and American political thought began with the idea that you should assume that nobody would be an angel. So now we've turned the court into basically a tyranny, and you're saying, don't worry, the tyrants are going to be milder in the future, so we can trust them. And I'm very wary of that, because it's very rare that someone really gives up power.
Yeah, but if you are, let's say you are more right-wing, or you more lean to the right-wing on the Supreme Court, and the Israeli government is also right-wing, then you're more willing to delegate or return some of the powers. Okay, but I agree with you. It's very hard to take power from institution. It took the New Deal crisis in the US during the 20s with Roosevelt to threaten the court, impacting the court, that made the court actually change its complexion, and some of the judges resign. Okay, so I agree with you, but now there are some kind of discussion again about maybe structuring a narrow kind of constitution with the Israeli basic law legislation, which would actually define the terms of adapting a basic law, and after, if, for example, in order to change a basic law, you need a very substantial kind of members of the Knesset, then there won't be any judicial review on constitutional amendment, and that might be the solution. Another solution is to reenact the reasonable amendment case. By the way, now the court is more conservative. It's changed, but to define it more narrowly, to say, well, we should adhere to the Westbury test, and the court should not lose track from it. That's also a possibility. I agree with you that the battle is only in its beginning. Okay, let's remember in December 29, 2022, the Israeli government, the right-wing government that launched the reform, was established. In January 1st, only a year with 2 days in difference, the court's decision launched a decision on the striking down of this reform, and actually made the impression that no reform can be taken in the future. I'm more optimistic. I think many people also on the left wing move in unease. They know that sometimes they might be in power and that won't serve their interests. And I think maybe now there is an opportunity to get into sensible agreement. And I think there are good solutions on the table that are both democratic, both liberal, but both maintain the Jewish character of the State of Israel. Maybe the future holds some promise.
With that, we'll end. With that optimistic thought, I think you were cut off, so I'll just repeat the sentence. Maybe the future holds some promise, you said.
Some promise, yeah.
Professor Moshe Cohen-Eli, it was a pleasure to speak with you. Thanks for making the time.